Arguments. The petitioners argued that the RBI lacks the authority to prohibit virtual currency from trading through virtual currency exchanges because virtual currencies are not legal tenders. As commodities or digital goods, virtual currencies do not fall under the purview of the regulatory framework of the RBI or the Banking Regulation Act 1949. The Indian government's Department of Economic Affairs, the Securities and Exchange Board of India, the Central Stock Exchange of India, and Board of Direct Taxes were just a few of the parties the petitioners cited as examples of changing mindsets. The petitioners pointed out that in contrast to the RBI, which has adopted a different approach without any justification, these parties have recognized the benefits and advantages of cryptocurrencies as digital assets. The petitioners drew attention to the RBI's deliberate concealment of the fact that not all cryptocurrencies are anonymous. They presented a study from the European Parliament that divided virtual currencies into anonymous and pseudo-anonymous groups. Therefore, in their opinion, RBI should have forbidden only anonymous virtual currencies if the issue sought to be addressed was the anonymity of transactions. They also argued that the virtual currencies do not fall within the credit system of the country and therefore enabling the RBI to decide its mode is questionable. The petitioners also expressed their surprise at the RBI's dichotomy that cryptocurrency is illegal but blockchain technology is accepted. The petitioners further argued that the benefit of the rule of judicial deference to economic policies of the state is not available to the RBI, as a circular by the RBI is an exercise of power by a statutory body and is neither legislation nor an exercise of executive power. The petitioner stated that a total prohibition, especially through subordinate legislation, such as a directive from the RBI, of an activity not declared by law to be unlawful and is violative of Article 19, Clause 1, Subclause G of the Indian Constitution. In this case, the RBI took a stance that virtual currencies do not satisfy the criteria required for being acknowledged as currency, such as store of value, medium of exchange, and unit of account. The central bank pointed out that the virtual currency exchanges do not have any formal or structured mechanism for handling consumer grievances. Virtual currencies are capable of being used for illegal activities due to their anonymity and pseudo-anonymity. The RBI highlighted that the increased use of virtual currencies would eventually erode the monetary stability of the Indian currency and the credit system. In the opinion of the RBI, the impunged decisions were necessitated because virtual currencies transactions cannot be termed as a payment system but only peer-to-peer transactions, which do not involve a system provider under the Payments and Settlement Systems Act. Also, no one has unfederated fundamental right to do business on the network of the entities regulated by the RBI. Despite this, virtual currency transactions have the potential to develop as a parallel system of payment. The judgment. The Supreme Court acknowledged that the RBI has not found in the last 5 years or more that the activities of virtual currency exchanges have impacted negatively the way entities were regulated by the RBI function. The Supreme Court also observed that the RBI's consistent stand has not prohibited virtual currencies in the country. The Supreme Court cited the case of the Inter-Ministerial Committee, which thought that a ban might be an extreme tool and that the same objectives can be achieved through regulatory measures. The Supreme Court stated that the concern of the RBI should be about the entities regulated by it. However, the RBI has not come out with any stand that any of the entities regulated by it have suffered any loss, directly or indirectly, on account of the interface that the VCEs had with any of them. In the state of Maharashtra versus Indian Hotel and Restaurants Association case, the Supreme Court held that there must have been at least some empirical data about the degree of harm suffered by the regulated entities. The Apex Court determined that the RBI had failed to meet the aforementioned stand before the restriction and did not comply with Article 19, Clause 6 of the Indian Constitution. The European Union's July 2018 report suggesting a complete ban on cryptocurrencies was not necessarily to govern the banking industry, was another source the court cited. Before enforcing a total ban, the court noted that the RBI had not taken into account less intrusive options. Finally, the court decided in favor of cryptocurrencies after using the doctrine of proportionality. As a result of these prominent interpretations, the RBI's circular was declared illegal and set aside, paving the way for facilitating the exchanges of cryptocurrency traders not only in India but around the world. Importance and impact. The Supreme Court's ruling highlights the value of judicial scrutiny about choices made on economic policy. The RBI circular was overruled by the Supreme Court because it was disproportionate to its intended goal. It should also be noted that Supreme Court had not many comments on whether virtual currency is genuinely legitimate or not. The judgment, therefore, does not eliminate the ongoing dangers connected with trading in virtual currencies, which are still not subject to regulation in India. The judgment resulted in the boom of the virtual currency industry in India and abroad. A notable increase in the trading of virtual currencies have been observed in India since the relaxation of this ban. While this judgment marks a positive step towards the growth of cryptocurrencies and exchange technology nationwide, there are still lingering concerns about possible misuse of virtual currencies for money laundering, terrorist financing, etc.